So what's a trademark and why is it so important to register your mark with the US Patent and Trademark Office? Well, let's talk about that. Are you ready? So trademarks are a type of intellectual property. The property itself is intangible. You can't touch it or feel it, but it can be bought, sold, inherited, traded, and protected. I like to think of trademarks as one of the easiest ways to distinguish your goods and services in a saturated marketplace. Now, take a look at the brand shown on this slide. When you see these marks, what do you think of? Let's go through a few. When I see this apple with the bite mark, I immediately think of Apple Incorporated and all of the mobile devices and computer products and services that they offer. When I see the scripted wording Coca-Cola, I think of soft drinks and beverages. When I see the wording Ford, stylized just like this in this oval, I think of cars and trucks, and I don't think of Dodge. All of these trademarks are tied to goods and services. And so that's the rule I want you to take with as we move forward. So what exactly does a trademark do? Well, first off, trademarks are like information shortcuts for consumers. They let customers know where a good or product or service comes from. Trademarks indicate the source of goods and services. Second, as I mentioned earlier, trademarks are how a customer will recognize your goods and services in the marketplace. Trademarks help customers distinguish goods and services from a competitor. And third, well, if you have a trademark, you have legal protection for your brand. In other words, if you have a trademark, you have a legal recourse if a competing company uses your brand name or brand design, etc. So now that we've talked about what a trademark does, let's chat about what it doesn't do. Here are a few reminders. Just because you own a trademark does not mean that you legally own it or that you can prevent others from using it, or that people owe you money if they say your word or phrase. Remember, you don't have rights to the word or phrase in general. You only have rights in how that word or phrase is used with your specific goods and services. Let me see if I can give you an example. Let's say that you use the wording Archie's Auto Mart as a trademark for your small automotive repair business. And you use that mark to identify your car parts and car repair services from others, okay? Great. But this doesn't mean that you can stop others from using Archie Auto Mart for bakery services or cupcakes. Why? Because bakery goods and services are unrelated to auto parts and auto repair services. A trademark owner doesn't own the mark. A trademark owner owns the right to use the mark to sell specific goods or services. Now, some folks have asked, what is the difference between the wording trademark and service mark? Well, technically, the word trademark is used to refer to marks that identify goods, while a service mark is used to refer to marks that, well, identify services. But these days, the word trademark is used interchangeably to refer to both trademarks and service marks. Now, traditional trademarks include brand names, slogans, and logos. Let's see if I can give you some great examples. When you see this wording Coca-Cola, you notice this in all capital letters. This is called a standard character mark or a brand name, and it is used to identify soft drinks and beverages owned by Coca-Cola, of course. What about this one? It's the real thing. This is a slogan, also used by the same company to identify soft drinks and beverages. Finally, here you see some designs, a logo with wording and imagery for use in identifying soft drinks and beverages, just like the other two before. And you also see this logo here, which also could be considered a configuration mark, sort of that shape of the Coca-Cola bottle. That's actually a mark too. That's called a non-traditional mark. And let's see some more examples in the next slide. Remember, just about anything can be a trademark so long as it indicates the source of the products or services. It could be a word, a slogan, a design, or a combination of these, but it also could be a sound, a scent, or a color. Let me give you some really fun examples of non-traditional marks. What about sound marks? Did you know that the sound that the lightsaber toy makes is actually a trademark owned by Lucasfilms? And the goods that it identifies are actually toys or costumes. Did you know that the color orange, for use in identifying candy, is owned by Hershey and is used for typically for Reese's peanut butter cups? Did you also know that the scent of a product could be a trademark? Think about Play-Doh. Now, if I pop the lid on this, I will be transported back to kindergarten. The smell of this particular molding clay is a trademark that's owned by Hasbro. And what about motion marks? Can you close your eyes and think about the motion that the doors make on a Lamborghini? This motion that goes up something like this, a butterfly motion or a scissor door motion, is actually a trademark. When customers see that, they automatically think of cars that are made by Lamborghini. And what about holograms? You know those stickers that you find on the American Express? Well, those are also trademarks. This hologram design on that sticker is a trademark. And when a customer sees that, they know that they have an American Express card. And what about one of my favorites, the configuration or the shape of a product? Did you know that the shape of this particular bottle is owned by Coca-Cola? And even without the wording or the brand information, you would know that this was made by Coca-Cola, that they are the source, and it's used to identify soft drinks and beverages. Non-traditional trademarks, just like brand names, phrases, and designs, function as source indicators, and they can be entitled to trademark recognition, registration, and protection. These are trademark fundamentals.